Welcome. This is our 9th lecture in Principles of Company Law. We'll be continuing from where we left off last week when we were looking at directors' duties. Now we'll be looking at the primary method that directors' duties are enforced, which is the shareholder derivative action. We'll look at the nature of the action by looking at the control within the company, how it is arranged, and the risks of minority control. And then we'll look at the derivative action as it arose in common law. And finally, look at how the derivative action arose in statutory law, which has increased the number of derivative actions in Hong Kong by about sixfold when the statutory action was brought in 2005. So the problem with the derivative action is the companies are regulated primarily by majority rule. But with a derivative action, we will allow one member, a single member, to take action in court which can change the direction of the management of the company and bring to liability the directors of the company. So what we have in the legal system is essentially very simple. This lady represented on the slide is supposed to represent someone who is civilized but fragile. Now, if someone who is not civilized and strong then acts, let's say, through majority power in the company to damage this existing member in the company, then really what the minority or the less powerful member in the company is left with is only the possibility of prayer. And a prayer is what we're looking at today, because the prayer then goes to the court, a pleading to the court that was referred to once as a prayer. And the court will try to understand whether the action that has damaged the member is in violation of, let's say, the fiduciary duty or the duty of care of directors. Those two duties are often analyzed in a derivative action. If the court finds that, in fact, there has been damage to the minority member by someone more powerful, then the court has the entire apparatus of state power behind it and can make sure that the danger is eliminated. And that's the circle that we see in the legal system, and you're well acquainted with it. And this is something that allows a single individual, provided they have a right, and that right has been damaged, to seek redress, and the state will back them up if their cause is found to be well-founded and just. So we bring then the minority member back to a state prior to where it existed before the damage. And now when we look at the minority member, we're looking at also that minority member state of being would be in a company which is no longer subject to the damage that the company was previously being subjected to. So because we're in a company law setting, we're looking at this plaintiff as a member in a company, and we're looking at the damage as something that does not concern the plaintiff personally, but concerns the company. And that is why the action to protect the company would be understood as derivative. There's a problem when we allow a minority to control the company. Let's say here we have this situation, and the bull can take the place of the minority member. Now, this bull is now 0.3% of the shares of the company. Yet, given the power of the court and given the availability of the derivative action, this bull, this minority member, will be able to shape the behavior of, let's say, 85% of the voting rights of the company. And so this could turn from a situation where we have the protection of minority rights into a situation where we have domination by the minority over the persons who actually own the company and invested the most in the company. And this is a problem of governance that the structure of the derivative action tries to address. So the problems are quite a few. So first of all, we have this majority rule of investor control. Persons invest money into the company or other assets into the company, and they receive shares of stock in return. Those shares of stock will be linked to voting rights. And if a single member with a very small voting right is able to influence the behavior of the company, that conflicts with the principle of investor control. It also conflicts with the economic incentives. If I invest a large amount of money into a company and I receive, let's say, 85% of the profits made by that company through dividends, then I have an incentive in the success of that company. If I invest only a very small amount and I receive 0.3% of the profits of that company for dividends, my incentives are not strong to see that company succeed. And so minority control can distort the behavior of the company. Also, when the court makes a decision on whether the management has acted properly, the court is making a deductive decision with the state controlling the activity of economic actors. And this is generally considered to be problematic given that judges are not skilled business directors, and also the governments normally should not be in charge of the commercial affairs of private citizens. Also, if members interfere with the activity of the directors, we know that members may not have management skills. In our case, we have a member, OK, who probably has some management skills, but think about whether Mr. OK understands the technology of the mom in the cases that we've been looking at this term. And so a member may not always be able to make a judgment as high quality as the judgment which is made by the director who's being challenged. The minority also may be investing in a competitor. A minority may decide to take 1 or 2 shares in a competitor and then bring that competitor to court in order to distract it and bleed it of resources and gain a competitive advantage. Also perhaps receive disclosure of information in the judicial proceedings which could be useful for competition. So there are a number of reasons why minority control through a derivative action is not a very good idea. And so in the derivative action, what we have is essentially a filter or a balance which tries to prevent abuse of derivative actions and allow in only the favorable or the useful and beneficial derivative actions. Now, the culture has changed significantly. If we look at the beginning of the derivative action in the mid-19th century, we see a culture and a state of the common law in which the derivative action is generally rejected, except in very special circumstances. If we fast forward to Hong Kong, which is an international financial center, we have an entire economy which depends on its reputation for investor protection. Therefore, the possibility of a damaged investor seeking redress in court fits with the very structure of the Hong Kong economy, and it is no surprise that in Hong Kong, investor protection is seen as more important than it was in 19th century England. So we'll look first at the common law derivative action, and note that after 2003, we do not have any filed common law derivative actions in Hong Kong. Plaintiffs choose the statutory action simply because it is a better route to take if you are a plaintiff. So some useful terms with derivative actions First would be the distinction between a personal action and a derivative action. A personal action is where there is a specific right of the member which is damaged personally, and that would, or another person who is damaged personally. And in a derivative action, what we're looking at is primarily a director, but it could be someone else, is damaging the company. It is the company's right which is being defended in a derivative action. In a personal action, one is defending one's own right. In the unfair prejudice action that we'll look at in week 11, we have a personal action. Here, we are looking at derivative actions. A reflective loss is generally not considered to be a ground for a derivative action. Now, if I own shares in a company and the director damages that company, then the value of my shares will decrease. And so I do have a personal loss. That will not ground the kind of action we're looking at here. So the argument that one's shares have been decreased in price will not be an argument that supports a derivative action. In a derivative action, the court will look to the interests of the company and damage being done to the company and not to the member. So this is not a personal action, and we are not looking to redress reflective loss. So the derivative action, as I said, derives from the wrong done to another, here the company, and the member is acting on behalf of the company. You'll note that that is a very extraordinary thing to do, the member interfering. And that's what we see in the original case of Foss and Harbottle in mid-19th century England. This is the estate which the action regarded, Victoria Park in Manchester. So two shareholders brought an action against those who they saw damaging the company. And the allegation was misappropriation of assets belonging to the company. The court ruled that the shareholders should not be interfering with company management in this way. And so they found that the proper plaintiff would be the company itself, who acts on behalf of the company itself. It would be the directors. So the general principle that we draw from the Foss decision is that minority shareholders cannot sue for the wrongs done to their company or complain of irregularities in the conduct of its affairs. That will be an activity which is prosecuted by the board of directors. So the principles are, as I said, we have the proper plaintiff is the company, and we also have a principle of majority rule, which is retained to a certain extent even today in the statutory derivative action, that the majority may simply ratify actions by the board of directors or by an individual director or others which are alleged to have damaged the company. We do have exceptions, or we wouldn't have derivative actions. And so a number of exceptions are relatively empty and not terribly useful, but the last exception on this list is the one that you want to focus on. So first of all, from a clearly doctrinal point of view, a strictly doctrinal point of view, and we discussed this in our third lecture, if the company has no power to act, then the company cannot repair an action which is ultra vires, because the power never existed and there's nothing there to repair. And so you can see the logic that this would be something which cannot be ratified if it is ultra vires. Today, ultra vires actions actually are held in place, such as an allotment of shares or a contract beyond the director's power under section 117 in the latter case. So the transaction in question required a special majority, which was not achieved. This is a bit formalistic, and it's hard to believe that there would be a practical use for this, that they didn't notice that there was a special majority necessary, and they didn't achieve that. But again, we're looking at things which are formalistic and clear-cut and do not regard directors' discretion. Another is that the judicial action is actually personal, as the company injured a personal right of the member. This is a very strange exception. Actually, I'm telling the truth that this is listed as an exception to the rule on Harbottle. This was a bit, it's a bit like saying, all right, now, when you come into the lecture theater for this course, you may not smoke. And then someone accuses you of smoking, and then you raise your cup and you say, I'm drinking coffee. This is not smoking. And that is seen as an exception to the rule against smoking, that you may drink coffee because coffee is not smoking. You see, this is a kind of ridiculous exception. If the action is a personal action, it is not a derivative action, and so there is no need to file a derivative action. So that this would be an exception to the filter against derivative action is a bit strange. So let's not think about that exception. Now, the exception that we should think about is fraud in the minority. Essentially, the idea here, as I'll give you in a second, is that the board is controlling the company and the board is doing the bad deed, and so the board will not act to correct its own bad deed. Right? That's the simple point, and that's where we focus, and that's where we find all of the derivative actions. Right. So first of all, forget the personal action as being an exception to the derivative action. It is not an exception. It's a different kind of action. Coffee is not an exception to smoking. Coffee is not smoking. Now, the Companies Act being fraud in the minority is a very practical kind of an action. And as you might expect, this is something that is raised by the father of practicality in common law, Lord Denning, when he simply points out that if there is a group in charge of the company, and if that group is damaging the company, you can't very well expect that group to sue themselves and protect the company. And so in that case, it is necessary that someone else be given the right to sue and protect the company derivatively. And that's pretty much what we have in all